Susanna, today what we wanted to talk about was an issue that you've, of course, identified just recently, but we always, not always, we often run into, and that is what do we do with an estate that we're administering that includes a business asset? And one of the things I always like to do when I'm looking at issues of this nature is, first of all, talk about what I'm not going to cover. And so we're not going to cover the sort of the nuancing of the specifics of corporations and corporate law, such as like shareholder disputes or, oppression remedies, things like that that may impact an estate. And we're also not going to talk about winding up or wrapping up the deceased business. Much of this is corporate related work that we're going to touch on just at a very high level. But what triggered me to want to cover this issue with you was 2 points. One is, of course, your Probator, which is our monthly email and hard copy for those who still ask for hard copy newsletter. A newsletter that's at volume 30, so we've been doing it for many years. And we have covered this issue in the issue number 2 in June 2024. So if you're interested in getting some of the detail on this, you can get an actual hard copy of the discussion we're having today. But and just before you jump in, Suzanne, I wanted to just sort of set the stage. But before I do that, did you have any opening comments before we sort of set the parameters of what we want to cover today?
Only to say that it's funny that over the years, I've seen many more of these estates and the administrations that suddenly do have a corporate or a business component to it. And that was sort of the reason that I got interested in thinking that let's talk a little bit about it and with the Probator on that, because I suspect people have the same kind of experience, that there's more of these things, especially as these estates are getting larger. They tend to be more complicated. And in many cases, we're running into these issues almost regularly.
And it's so true because it's not, not the very rich that have businesses. Most of our clients run into situations where they might be of an operating nature of their lives that when they pass, they have to nuance. So my scenario is this. You get in a situation where often an executor is charged with the obligation to pass on a corporate asset. Now, passing on a corporate asset brings with it a lot of tension because it's a question of whether or not you're going to hand over the operating business as is or not. Are you going to try to pass the shares over to the beneficiaries in specie or not? All competing against things like, are there business loans out there? Is the bank on the case of the on top of this? Is CRA angry with the deceased before they died? You can see what sort of intermeddling of third parties can bring to this. So I see these situations a lot where we've got a case where quite properly, there's a well operating company doing OpCo is producing something or selling something in a business-like fashion, but it relies heavily on cash flow. So it'll have a significant amount of debt protected by general security agreements or other types of corporate security. And certainly in my experience, Suzanne, I don't know what yours is, but you'll see the banks will typically jump all over the executors to the point of they sometimes will react in panic once the head of the company, so to speak, has passed away, and they sometimes overreact and look to charge in on the security in a way that is sometimes almost impossible to manage.
And very, very detrimental in many cases to the company itself.
And then, of course, you've got situations where someone might have a small business and they're already either on the hook or they've created an arrangement with CRA where they're paying over time or something like that. Maybe they're behind on the HST and things like that. And so you've got these what are essentially, business operation problems beyond just keeping the business going. And often the executor, A, has to manage those two elements of it, and B, of course, has to be a business person. And that business person, whether they haven't been day to day in the business, so they have to put their business hat on. And so a lot of the advice that I try to give people in these situations is to really focus on getting good advisors around you, tax, corporate, if it's close to insolvency advice. Get that advice around you and put on your business hat, whether you're a lawyer or you're a friend but act like a business person and make business-like decisions that are fully documented. And don't try to do both. Don't try to be the lawyer and the business person, because if you or your clients running into this situation, they've got to refocus and they've got to be operations. Focus on operations, because of course there's always the tension that a beneficiary will want the actual business passed on to them. And when I say that, they'll want the shares in specie passed on to them. The difficulty, of course, is that all of the liabilities of the business, not of the estate, have to be paid first. So you've got classic residue gifts. Say the deceased owns a house and they own a convenience store, and the convenience store has some GSAs over it, and it's got some loans against it, and the house is mortgage free, and it's all the same beneficiary. So you've got to manage, maybe you can sell the house quicker to keep the bank off your back, or do you want to sell the business, but you don't want to sell the business in a fire sale? And the real estate market's a bit dampened right now, so maybe you don't want to sell the real estate. All of these, I'm just describing those as business decisions you need to make sure your executors are making. Then you take those business decisions and you overlay them into the legal advice. So that's sort of just my starting preamble of what I try to set the stage for with executors who are in this situation. Focus on being a business person, not on being a lawyer or an accountant or whatever, or friend, what your other job is. So Susanna, that's sort of just setting the stage a little bit about that, what we want to explore, and maybe it may take more than one podcast, but on this podcast, what's your first step that you want to take, though? Your very first step you want to take when you have a situation in any estate, but in particular when you have a business operation that you know has to be administered?
Well, the first step, of course, is to read the will and to see if the testator had the foresight to work with his advisors or her advisors to talk about what they actually intended for their company. Did they intend for there to be the business to continue on as a running concern, as you had suggested? Do they intend for it simply to be transferred to the beneficiaries in a very quick fashion? Did they intend for there to be an option to purchase the business, perhaps, or have some other individual run the company, in their absence? So the terms of the will, of course, are always going to be the starting place in terms of figuring out what is ultimately going to happen with that company.
And it's such a good point, because the instructions in the will, of course, can also be problematic. I've seen, and I'm not a big fan of this kind of drafting, but I see it lots from time to time, is that the deceased will give shares of the business to someone or a group of individuals. And that group of individuals may be different than the residuary beneficiaries. So it might be, I want Jimmy and Freddie to get the business, and they'll use the word shares, which is awkward, because of course if you're given shares, then the underlying intention would be to give the business operations to that person, those two people, which could be problematic if you've got a whole bunch of personal liabilities on the other side. And then secondly, of course, is that if you have the different individual, so Betty and Betty's gets the residue, and so you've got three people on the table and competing interests as to, do we keep the business going? Can I use the personal assets to prop up the business in the short term to get the bank off my back because I want to sell the business or I want to pass the business over? Those are the kind of tensions that you're playing with all the time when you're dealing with a business operation. And of course, that's where what we do have some remedies available to us when we've got a situation where language is problematic, don't we, Susanna?
And many times we'll see instances where we're telling the executor, we should seek the court's opinion, advice, and direction on what that provision in the will is intended to mean, or what it does mean, or how it should be interpreted. And we've got that the benefit of Section 60 of the Trustee Act here in Ontario, where you can put these kinds of questions to the court for what we call the opinion, advice, and direction on how to manage this particular asset and within the confines of the whole estate administration. And that, I mentioned a couple of cases in the Probator article where you see instances where people do have to go to court to seek clarification, because despite all of our best intentions and what we view as very tight drafting, sometimes in actual practice and trying to affect those provisions and put them into play, it becomes a little bit uncertain. And the clearest way for the the executor to get the advice and the direction is to have the court, give them that guidance so that they can't get criticized if someone were to disagree with the decision at the end of the day.
And I noticed that you're right, those cases are interesting. I mean, one of them even talks about having to go to court to get direction as to what the term, quote, my business, end of quote, means in the will. So language is crucial, and in East State, we've overcome that with the language we're using to ensure that that isn't going to be a problem. But of course, that can be a problem in the drafting. Susanna, so you mentioned the idea of checking the will and making sure that you've got the terms of the will understood and that you've matched up beneficiaries and so on. But one of the realities is we have an executor's year. And is there what role or what considerations do we need to think about when we're talking about running the deceased business in the interim? So you've got date of death, and you've got the business. The deceased sells patio furniture, and it's a going concern. It's great cash flow. It's driven by huge volume, and therefore has a big bank loan to carry the line of credit. But the cash flow has always been there. As long as the sales are there, it runs great and has created a great lifestyle for the deceased and now for the beneficiaries. When you're faced with a situation like that, when it appears on the face of it viable operationally, some heavy load on it from a debt standpoint, but viable operationally, what are some of the considerations you want to think about with whether you run the deceased business in the interim or not?
Yeah. Well, if the will provides for a certain situation, of course, you're going to abide by that. But if it doesn't speak specifically to something like an option to purchase or carry it on as a going concern, it's interesting that the cases actually suggest that simply by virtue of being an executor, you don't automatically have the right to continue a business for however long you might choose to do so, whether it's the executor's year or beyond. And so you certainly have an obligation to maintain the asset, just like you would any other asset, and make sure it's protected. So, if there were to be, for instance, an option to purchase in the will, you'd be maintaining that business as best as you could for that period of time until someone who's provided with that option decides whether or not they're going to exercise it. And then at that point, we'll be considering, what are we going to do with it? Is it going to continue on and for how much longer? Or are we going to take steps to wind it up or to distribute the shares? And seeking guidance always from professionals, I think, is the best way to do that, to make sure that you are maintaining that asset so that you're not going to get criticized for not having properly dealt with it during the administration.
And of course, as important as it is, the most important is, of course, read the will. But another important early step to take is understanding the business. What are we dealing with? Is it truly an operational business, or is it a cash business? Is it an investment business? Is it, what is the nature of the assets that are in the business or businesses? Maybe it makes sense to just simply wind up the business from a standpoint of administration quickly, because it's a question that can be liquidated easily. What I'm most difficult situations, of course, are where there is some operational element to the business. But if you have a situation where it's an investment type business, you also have to consider, of course, the nature of the assets and your nature of your obligation to follow the considerations under the Trustee Act with respect to investment. Again, we have to keep balanced portfolios. The courts have expected that under the sections of the Trustee Act with regard to investments, expectations, and so on. But it's just so important to consider all of these things. But if you don't get in early and figure out what business you're actually operating, what type of business you're operating, you can make mistakes. So I really like that point, Susanna. So continuing the business to operate sort of temporarily, what are some of the things that, of course, an executor is going to have to almost immediately concern him or herself of?
Yeah. Well, like you said, if it is an active business that is running, they're going to want to go in and make sure that they understand the nature of the business. They're going to want to see who the employees are. They're going to have to consider how those employees continue on so that the business is protected and being run as efficiently as possible, even though the testator has suddenly passed away. We're going to be looking at salaries. We're going to be looking at, instances where perhaps we will have to terminate some individuals. So you are an executor, you're wearing your business hat nonetheless, and you're of course seeking advice from people who, may be more knowledgeable in the area, because we know that not every executor is a professional. But if they're taking on this role, it comes with a, tremendous responsibility, and making sure that we're meeting those expectations is so important, particularly if, you mentioned a couple of times, just financing could be an issue, right? Do we have sufficient cash to keep the business afloat? We know we are supposed to, either for, a certain period of time or for whatever the conditions may be. Money has to be coming from somewhere, and that's where, we'll want to give consideration to the global nature of the estate and what kind of assets are available, and ultimately who the beneficiaries are that are going to be affected by each individual part of the administration.
And coming back to financing, one of the things that you'll see lots of good business people will do is have life insurance. Now, corporately owned life insurance is not always easily payable until you get probate. It's so again, what you might sit there and say, okay, that's okay. There's gonna be lots of money coming because I got life insurance, and it'll keep keep us afloat while this interim period is on. But the corporately owned life insurance, I do lots of times find that the banks, the insurance companies are expecting probate before they will distribute the corporately owned life insurance, especially in situations, of course, where there's only a single will. But these are things that you want to make sure that you've got a handle on. But Susanna, what are you talk about operating the business as a going concern in this interim temporary period? What is the exposure to the executor if they choose to operate as a going concern in this interim period?
It's personal exposure for sure. They could be liable for if the business doesn't do well, if there are losses, or if there are debts or expenses that aren't properly being paid that are incurred to run the business. It is a very onerous position that's being taken on. And of course, we could look to, the forgiving provisions of the Trustee Act, as long as someone's acted, honestly and fair and reasonably, and ought to be excused for what might be alleged to be a breach of trust. But it really is an important job, and it is one that comes with a lot of responsibilities.
And it's not easy. There's no easy answer. I mean, if you just say, well, we'll wind up the business, but it's an operating business that requires, movement of inventory to create profits, to generate, keep the lights on, sort of thing. It may have no value unless you keep it operating. And so, of course, that's the balancing act that the trustees have to make the decision on. Do we keep the operational side of it going to hopefully wind it down, or sell it in a way that is not under a gun, so to speak? So before we make that decision, what are some of the early steps you want to consider? The estate trustee, who would they want to look to in terms of trying to make the decision, go or no go with the business?
Well, if the executive doesn't have the particular knowledge or the experience themselves, they could always look to, a third party to perhaps run the business in the meantime. Someone with expertise in the area would, of course, require the assistance and the cooperation of the existing employees in that. But having someone with a bit more knowledge running it will certainly take a little bit of pressure off the executor.
So that's a great idea, and I think what we often, and I know there are people out there, and I've certainly worked with them over the years, that will come in as temporary CEOs, and they may not have the expertise precisely of let's just come back to the patio furniture suggestion. They may not have that particular expertise, but they have expertise in running small businesses or running large businesses, and so looking to getting the delegating the task of running the deceased business is all fine, and it's all well within the parameters of the trustee powers, as long as you're you're not delegating the decision making. You're delegating operational decision making. You're delegating advice in terms of, they'll come in and say, listen, the financial statements haven't been made up to date for 3 years. The temporary CEO might have some suggestions on how much inventory they should buy or not buy, but ultimately the buck stops with the executor. But you're at least going to this third party source, and the beneficiaries would expect you to, and I think a court would expect you to seek the proper advice. You have the right to delegate and seek the proper advice. What are some of the, what may be good practice though to keep in mind though at this stage, if you're going to delegate the task of running the deceased business to a third party? What's some good practical advice to consider, Susanna?
I think one of the advantages of delegating to a third party, as you suggest, is the fact, of course, that you're avoiding a potential conflict of interest, right? As an executor, you owe your duty of, good faith and loyalty ultimately to the beneficiaries, whereas someone who's running a company is going to owe a duty of loyalty to the company itself and to the business. And so in those cases, particularly if we're considering that there could be issues with the ultimate beneficiaries, it's kind of cool to keep those two roles separately. And when we are, overseeing someone else's management of the company, because of course a trustee or an executor has to oversee effectively any delegation that they put into place. We can have these individuals be reviewing corporate documents to ascertain the ownership structure of the business, to make sure that we're understanding how it in fact is being owned and operated. If the deceased was a professional, like many of us who have, professional corporations, if there's a regulatory body that might be involved, consulting with that body might be another good way to make sure that we're fulfilling our duties properly as an executor or an estate trustee.
And, coming back to the earlier points you were making about practice to ensure that you protect yourself in these situations. A couple thoughts I have. One is, of course, if you're going to choose to delegate, and especially if I use the situation of maybe getting a property manager in as an easy illustration, if there's a few properties, or if bringing in an interim CEO, you want to make sure that you've selected that person or that company very carefully. You want to have documented it. And I can never say this enough. You want to tell the beneficiaries your thinking. You want to report monthly. It's as important as it is to report to the board if you've got a board of directors to deal with, or that you treat them like the beneficiaries are like the board of directors, and you voluminously report on what your thinking is, what you're doing, making sure that they understand that you're at the helm and that you've got it well under control. And that, of course, you welcome any input. You don't want to suggest to them that this is it is a unilateral job and you have the buck stops with you, but you've got an open door to input. And of course, this is very important when you've got closely held family corporations where there may be people in the corporation that are directly involved in the day-to-day business. You may have the CEO being the father and the CFO, or one of the C-suite individuals is a family member, and would be obviously directly impacted by the sale of the business or its operations. And then you might have someone who's not in it. And so again, the best way to do this is document who you picked, how you picked them, and write the monthly reports to the beneficiaries as to the status of the administration, and put in as much detail as you think is reasonable and sensible to tell them what you're doing. So if you say right at the outset, I'm very seriously considering trying to sell the business quickly because we can't get ourselves under this heavy debt load that we're left with, and we don't have control over that because the bank has a GSA over us, and so I'm now out there looking for suitors, and I've hired this company to look for suitors, and I've hired them because I went through this analysis or these considerations. If you want to get even that granular, I'm not saying you have to in every situation, but the more information you can give your beneficiaries that about what you're doing, it makes it much more difficult for them to complain later. If they complain when you give them the information, you're at least able to respond to it. They say to you, geez, you know what? You should have hired Coldwell Banker, not CBRE. You say, well, this is why I hired CBRE as the real estate wing of the portfolio, because they have an intimate knowledge of the corner of, Portage and Maine. It's in Manitoba, of course, but an intimate knowledge of that area of the city. And I this particular broker I've worked with before produced well last time. That's why I picked them. You don't have to do that. It's just the more you transparently talk about the administration, the less they can come back at you with. And you can imagine, we all can sit in the chair of a judge, and they can say, oh, my dad used to describe it. People love to kick down sandcastles. They don't want to build them. And so if you're building the sandcastle, let them try to kick it down. because then you at least have an opportunity early and often to address the concerns or see it coming and decide how, okay, look, they're not going to talk to me about this. I can't have any dialogue with them about it. No problem. I at least know where it's coming. And you might want to power up a little more with advisors on that aspect of it. They might even be helpful. They might say, you know what, you didn't think of the rollover under section blah, blah, blah. And you go, you know what, I'll ask my tax advisor. And you may have not had your tax advisor on that issue yet. So the dialogue is something that, you know, many people take on the job of executor and try to keep it close in hand. But when you're trying to administer a business, I mean, I think in all estates, but especially when you're trying to administer business, advising the beneficiaries about what you're doing and what you're thinking allows for the dialogue. And if the dialogue doesn't happen, it allows for a judge to say, hey, she told you all about it. You never said anything. And now all of a sudden it's a complete disaster and you made all these terrible decisions. Of course, if you say nothing, they can complain about everything when you go to pass your accounts. So this is not just about the specifics of trying to run a business and operate it in the context of being an executor. It's about being a good executor. And when you get into a situation where you've got these more complex administrative duties, it's better. It's always good, but it's even better when you can over advise and as to what's going on.
Now, that transparency is really the key, because it's so easy to sit back at the end of an administration with the benefit of hindsight and saying you woulda, shoulda, coulda. This way, you know, you're being transparent, you're letting people know, you're inviting input if any. And in those instances where you're hitting loggerheads, you always have the benefit of being able to go to court to seek the court's advice and direction. So it's really the safest way to continue down that path of, you know, ultimately administering a business within an estate.
Well, that's great. I want to talk about on the next podcast, I want to talk about this is a little bit further and talk about things like, well, if we're overseeing the management of the business decisions and so on during the administration, what are some of the practical steps the executor could take? And I want to try to tease out some of the specifics when you talk about seeking advice and direction from a court. How is that really, what does that look like and when would you want to do it? And then of course, considerations relating to selling the deceased business. So those are really, I think we've covered a lot today. Those are just some more topics I want to get through in our next getting together. And I appreciate, Susanna, your help on this. And as I say, if anybody wants to get sort of a more fulsome description of some of these topics that we're talking about, you can go to the Probator under Hull & Hull LLP, volume 30, number 2, June 2024. And that's for the administering an estate that includes a business article that Susanna wrote. But I'm looking forward to talking more about this topic and more about your article at our next gathering together. So we miss Jordy as always, but good to see you, Susanna, and thanks for all your help.
Thanks everyone for joining us, and thank you.